Justice Jackson? Thank you, counsel. Rebuttal, Mr. Liu?
Thank you, Mr. Chief Justice. Just a few quick points. First, on miscarriage, we've pointed to dictionary definitions and pre-FTCA cases that show what the ordinary meaning of miscarriage was. The meaning was broad enough to encompass any time the male failed to arrive. I think the burden is really on respondent to point to something that justifies giving miscarriage a narrower reading than those historical sources show. She hasn't pointed to anything. I think the idea that miscarriage somehow incorporated some sort of model penal code-esque distinction between negligence all the way to willfulness is just wrong. Anytime the courts saw the male not arriving, they labeled it a miscarriage, and that's how we think Congress used it in the FTCA. On loss, on consistent usage, I didn't hear any reasons to give loss a different meaning in the postal exception than in the sovereign immunity waiver. I think the main reasons my friend pointed to was that there is language in the waiver that doesn't appear in the postal exception, but that's built into the presumption of consistent usage. The presumption has work to do only when the word as it appears in provision A is clarified by language in provision A, but that language doesn't appear in provision B. If that language did appear in provision B, you wouldn't have to apply the presumption of consistent usage. This is a heartland application of that presumption. And the next point on loss has to do with this whole business of converting the words Congress used into verbs. The words work perfectly well as nouns. They describe the consequences that certain negligent or wrongful acts can have. For miscarriage, it captures the consequence of the male not arriving, arriving late, arriving damaged, negligent transmission, the male arriving late or damaged. There's just no one consistent way to take Congress's language and convert it into verbs. And it's for the reason Justice Barrett mentioned. You can't just convert all these nouns into did the government X the male. It doesn't work with miscarry because miscarry wasn't used in that way. If you said that to a listener in 1946, they wouldn't know what you were talking about. Judge Cardozo's example in Heinrich is a good example. It talks about checks being lost in the mail, and it says the checks miscarried. And so there's no one way to redo Congress's language to make sense as nouns. I think what that tells us is just adhere to the language Congress used. It used nouns, treat it as nouns, and if you treat loss as a noun, there's no reason to give it a different meaning than the way Congress used it as a noun in the sovereign immunity waiver. Finally, just a couple points on my friend's approach to the exception as a whole. This whole separate ambit approach we think is misguided. The way I would think about Congress's thinking when it wrote the provision was it wanted to cover loss or injury to male. Loss or injury is the wording of the waiver. And so when it got to the exception, loss is a perfectly good word to use when describing something that happens to male. It thought we can describe injury using even more precise terms because there are words in our lexicon that describe bad things that happen to male. So it picked up miscarriage and negligent transmission. Does this mean that they could have, after written the three terms, just gone back and erased loss and negligent transmission? I mean, maybe if they were really confident in how courts would interpret the language, but by including loss and miscarriage in addition to loss and negligent transmission in addition to miscarriage, Congress guarded against three arguments that they were worried might have narrowed the scope of the exception. One is the very argument respondent is making in this case, that miscarriage should be limited to male going to the wrong place. Another argument that they wanted to guard against, presumably, is the argument that the Fifth Circuit accepted, which is that miscarriage is limited to instances where there is some preceding carriage or some preceding attempt at carriage. And the third argument they wanted to guard against was the idea that by including miscarriage, the only types of injuries to male that they were including were intentional ones. And so let's use negligent transmission as well. I think our position gives a coherent reading to the postal exception that avoids the deluge of suits that Congress was trying to avoid by putting the exception in the statute in the first place. And for all those reasons, we'd ask the court to reverse.
Thank you, counsel. The case is submitted.